Hello and good day, everyone. It is my pleasure to warmly welcome you to the 18th edition of Legal Insight. Today is Friday, the 12th day of June 2026. In this edition of the program, we will continue our discussion on shares. And today's focus is to answer two questions in relation to shares. The first question is, what happens to a person who loses an interest from being a shareholder in a company? Is he going to abandon the shares and move on without driving any value? Or the law has provided an opportunity for such shareholders, to acquire or drive value from their interest in the company? The second question we are going to consider is, what happens if a shareholder dies? Is legal representative going to step in and act in his place, or they are going to completely lose out? Now, to answer the first question, the position of law is that shares are transferable property. That means where a shareholder intends to transfer his shares, he is at liberty to do that. Or rather, where a shareholder loses an interest from being a shareholder in a company, he is at liberty to transfer his shares to other persons. However, as we noted in previous edition of the program, where a shareholder intends to transfer his shares to third parties, he has to first of all, offer the shares to existing shareholders of the company. It is only when the existing shareholders of the company fail to acquire the shares that the shareholder will be at liberty to offer it to third parties. This is known as preemptive right of shareholders. Now, what is the procedure for the transfer of shares? The procedure depends on the amount of shares to be transferred. For instance, where a shareholder intends to transfer all of his shares, a deed of transfer will be executed by the shareholder transferring the shares, who is known as transferor, and the person to whom the shares are being transferred, who is known as transferee. The executed deed will now be stamped upon payment of stamp duties. Thereafter, the transferor will hand over the executed deed and the share certificate in respect of those shares to the transferee. Subsequently, the transferee will deliver the document to the company for registration. Upon registration by the company, the name of the transferee will be entered as the shareholder in respect of those shares. Now, where a shareholder only intends to, transfer a portion of his shares while retaining some shares, the procedure is that the same deed of transfer will be executed, it will be stamped, and in this case, the transferor will now take the deed of transfer as well as the share certificate in respect of the whole shares to the company for registration. In this case, the company will now issue a new certificate to the transferor in respect of the remaining shares, while another certificate will be issued to the transferee in respect of the shares that were transferred to him, and their name will also be reflected based on their shareholding in the register of shareholders. Regarding the second question, where a shareholder dies, the procedure also depends on the nature of shareholding of the deceased shareholder. For instance, where the deceased shareholder wholly owns the shares, the procedure is that the title in respect of those shares upon his demise will be vested in legal representative of the deceased. These are usually persons to whom letters of administration are issued and not necessarily the next of kin of the deceased. However, where the deceased shareholder jointly own the shares with another person, the title in respect of those shares will be vested in the surviving shareholder. This procedure is known as transmission of shares. And this brings us to the conclusion of this edition of Legal Insight. If you find it interesting, stay tuned for more, and thank you for watching.